I see one counsel has their camera off.
Yes, Your Honor, this is Thomas McCauley. Yes, Your Honor, Thomas McCauley, co-counsel with Ms. Conkright. I was told as co-counsel I would not have my camera on.
Just checking. Thank you.
Thank you.
This is our third and final case for the day. It's 19 CV 480, Amos and Jones versus Catholic University of America. Counsel for appellant, when you are ready, please introduce yourself and let me know how much time you'd like for rebuttal.
May it please the court. Good morning, Your Honors. My name is Amos Jones, and I am serving as the person for oral argument on the brief. Joining by live stream are Arenderhit Dali of Dali PLLC, Arthur Hallgood III of Hallgood and Moran LLP, and Sumi Park of Amos Jones Law Firm. I alone will argue, and I would ask that we reserve 11 minutes for my rebuttal. Good morning.
11?
Yes, Your Honor.
Okay. You understand that presumptively you only get 15 to start, so you're giving yourself 4 minutes to start.
That is knowingly and intentional, Your Honor. Yes, thank you.
Very good. Thank you. And if I could ask both counsel for appellee to mute their mics. When you're ready, Mr. Jones. Thank you.
Thank you, Your Honors. The facts in this case are not in dispute. This case was severed from a larger employment case that's pending now at the Eastern District of North Carolina Federal Court. The severed count is tortious interference with contract relations. And for the 3 paragraphs of analysis in the Superior Court's opinion, dismissal for failure to state a claim or summary judgment, we simply point out the infirmities in the analysis of tortious interference, especially the intentionality requirement. And we are happy to supplement the record. The facts are not in dispute. Appellant, and I will speak in the third person to avoid confusion. Appellant filed the case timely and asserted that on February 21st, 2017, when the Dean of Catholic University School of Law, Appellee, contacted Appellant's supervising dean at Campbell University, North Carolina, and then sent an overture letter that in turn allegedly led to the abrogation of a terminal year of employment, that this nexus was a tortious interference with contract. We filed a Rule 28K letter, and we're happy to refile a 28K letter after oral argument. The judge below, the court below, is completely correct in calling on the Sidwell-Friends case, which is the case that dealt with the third element of tortious interference. The DC Court of Appeals in the Witt case, for which we filed the 28K letter earlier this year in this appeal, that third element is defined in the 2019 Witt case, the supervening authority from this court. Case of first impression on intentionality is defined as intentional interference with that relationship. And our position is that the intentionality is not a criminal type of intent. It's a typical restatement of torts type of intent. That is that the appellees intend to place that, apply those documents to the employer in contract known to appellee, and thereby cause harm to.
Mr. Jones, could you help me concretely, what facts are alleged in the complaint that would support a reasonable inference or would support a plausible claim that the Dean of Catholic, in sending the communication at issue, would have did intend, or maybe short of that along the lines of Witt, should have been reasonably certain that there would be a later, that Campbell would breach whatever contract might exist between you and Campbell? What facts are alleged in the complaint to support inference of knowledge?
In terms of knowledge, 6 paragraphs of the amended complaint found at Joint Appendix pages 10 through 11, and then again, Joint Appendix pages 79 to 80. The trial court ignored these facts as presented in Appellant's opening brief. Those facts are, Your Honor, that Catholic University of America on February 21st, 2017, intentionally discussed details of Appellant's private application for employment, details discussed with Campbell, without Appellant's permission. Within minutes of Appellee's conversation with the Appellant's boss, then reneged on Appellant's contract for employment, the terminal year, by informing Appellant that he would be terminated effective May 14th, 2017, a brand new breach of contract on the part of the former co-defendant.
I get that those facts.
Sorry, can I interrupt and just say we're having sound problems?
Yeah.
There's a substantial echo. And Mr. Jones, I think it would be helpful if it's possible for you to, when you turn your head, you're not speaking into the microphone. It makes it very difficult to hear you. And we want to get your argument.
Thank you, Your Honor. I hope that this is clearer and without interference. I read for the court's hearing paragraphs 3 and 4 of the First Amendment complaint. And also, I'll just call your attention to paragraphs 361, 362, and 363, and 364. Those are found at Joint Appendix pages 79 to 80. On or about, these are the facts alleged. And remember that under it, which this court follows, we need only show that it's plausible that these acts led to damages.
No, and let me interrupt you there, because the facts that you've mentioned concretely so far very much do go to a possible inference, a plausible allegation that the communication caused the breach in question. But what I'm struggling with a little bit more, and you just used the causation language, what has to be plausibly alleged in the complaint is that the Dean of Catholic intended that, or made short of that, would have been reasonably certain that a breach would follow. And that's where I'm not quite sure. Could you explain concretely why the facts that you're mentioning would state a plausible claim that the Dean at Catholic either was thinking, I'm going to make sure that Campbell breaches whatever contract it may have with Professor Jones, or that at least he should have realized it's pretty sure that if I send this, Campbell is going to breach whatever contract it has with Professor Jones. That's where I'm wondering what facts would make out a plausible. You don't have direct evidence of that alleged in the complaint. So what facts that are alleged in the complaint make that a plausible inference to permit the case to go forward?
In paragraph 362 of the complaint, Campbell University had no legitimate concern regarding the plaintiff's private email communication with the Catholic University of America. Paragraph 363, the private communication regarding a private and personal personnel matter would be highly offensive. These are lawyers and law professors and also a former federal judge in receipt of the material. And then 364.
Can I make sure I understand that? Because maybe I know that there are some questions that were raised about the American Association of Law Schools and what their understandings are, what people should or shouldn't be doing. But just generally, if someone who works at place A applies to place B, and the person at place B knows the person at place A and says, by the way, one of your employees, thought you'd be interested that one of your employees is applying for a position with me. That doesn't necessarily seem nefarious or mean that that contact is intended to or should be foreseen to have the result that person A, having learned that, will breach its contractual arrangements with employee A. So I'm just wondering whether you disagree and you think just the mere fact of that communication is so nefarious that it should support plausible inferences of a kind of a culpable mental state by the Dean of Catholic, or whether you think there are other facts that point in that direction here, or both.
Thank you, Your Honor. I think that it is an actionable event for a person in receipt of a job application to unauthorizedly communicate with the supervisor of the person making application. But the DC Court of Appeals in Witt believes it even more so, because the question of malice and intention to harm is reserved to the question of damages assessment. That's also consistent with Douglas Rosenthal versus Sonnenschein, Nathan Rosenthal, the 2009 case on jury instructions on tortious interference in terms of the malice part. So that's why it's a tort and not a crime. The appellees may have had no ill will. They probably had no knowledge that the recipient of this confidential application material was actively engaged in a total violation of contract and civil rights statutes, we argue, at the time. That's why the law is supposed to provide a remedy for such a tort, an accident, as we say. So when Witt is analyzed as that case of first impression, binding on this court, that unfortunately nobody briefed. It was a 2019 case. This case
Right, but Mr. Jones, if I may interrupt you, with the reason, which had to do with what the proper instruction was to give to the jury, right? But as you say, the instruction laid out what the legal requirement was, and it had to do with whether, not so much the evil intent, but knowledge, that the person would know that the interference is certain or substantially certain to occur as a result of his action. And in Witt, what the court looked at was, the evidence had been presented. The factual evidence that the alley was really obstructed, but importantly also that the owner of this beauty salon had in fact complained and told them, this is affecting my business, all the rest. So that there clearly was, again, they were on notice that their activities working on this alley was having a deleterious effect on this woman's business. Specific to the situation in this case, where you have somebody who is an associate professor in one institution and says, I'm an associate professor, I'm on a tenure track, I'm interested in applying to your school, and now I will go beyond the complaint because I read the letter, which goes on at great length about the reasons, and so very well laid out. There is nothing, I take it, or maybe you can tell me, is there anything inherently untoward about somebody who is an associate professor in one university and on tenure track applying for a position elsewhere? I would have thought not. After all, there are visiting professors from other universities. So I'm just wondering what would have put, going back to Witt, what would have put Catholic on notice that merely notifying Campbell of your interest in Catholic would somehow interfere with the existing relationship you had with Campbell University?
The Association of American Law Schools official guidance telling deans and others not to do that, which is cited and exhibited in the record below. That's the indication that reaching out beyond, including references, before a listed reference is checked. One under the ALS, which is the clearinghouse for law school professor faculty recruitment, much like the law school placement in law firms, there are clear published protocols. And the reason that the appellee is the Catholic University of America and not Dean Scordato personally, or not Dean Attridge, the two who are involved, is that at the time of the complaint, plaintiff had no way of knowing exactly who was behind it, but it was a corporate action in a school that is in the American Association of Law Schools that should not be doing that. If the
I understand that there's that guidance in that policy paper, but is it stated there, or is the reason because such disclosure, that confidentiality, privacy is required because it would interfere with existing relationships, contractual relationships?
That's the reasonable inference that everyone draws. It does not state that one who applies for a job could be harmed by his supervisors knowing that he is applying for a job elsewhere. That's axiomatic. It's an inference to be drawn. It's important enough to be in the rules, and everybody's on notice. Also, the restatement that's cited in Witt, and that also the court below cited, comment 766 in section 8A of the restatement, again, supports the view that the act itself of interfering or of going into the relationship is sufficient. These other questions are really things that might have come out one way or the other during discovery, but the facts are pleaded sufficiently under the rules of this jurisdiction in light of the 2019 opinion that properly interpreted Sidwell Friends being relied on by the court below, but not carried out to its logical.
Right, I'm just wondering, no, I understand that it's a different standard, that it's this, whether there's knowledge that that the interference is certain or substantially certain to result as a result to result from the action. But that's my question. What is alleged other than the fact that there was a communication without knowing what, well, a communication about the application, right? We don't actually have the notice as part of the complaint. The note, the Dear Rich note, it is, and what it says is not part of the complaint. For example, the trial court says, well, it's plausible that they just wanted to say, hey, this person, we're really interested in this person, would like to know your views on his qualifications, his effectiveness as a professor, all those things. What in the complaint kind of push this towards a negative inference?
The appearance of this letter, this private application letter of February 20th, 2017, in the defense position statement of the former co-defendant, Campbell University Incorporated, in April of 2017 at the EEOC. That moment is when the notice came to Appellant that there had been this meddling that was harmful, and explained why the terminal year suddenly had been. Tenure was unorthodox in its status. The terminal year, documents in the case in North Carolina now show, was a given all the way up until the time of this interference. In terms of the lack of discovery, to the credit of Appellee, they themselves supplied for the court below, found at Joint Appendix 254, the authentication by the IT folks at Catholic University of America, and at 249-250, Daniel Atridge, Dean of Appellee, Catholic University of America, telling the Dean of Campbell Law School, co-defendant Rich Leonard, in transmitting this application in February of 2017, FYI, thought you would want to know about this. And then it turns up. The other thing in the record, the other, not in the record, but on record, the other piece of evidence is that the General Counsel of Campbell University, who is a co-defendant in this case, is on record as punishing persons, seeking to punish persons who apply for jobs outside of Campbell University. That would not have been known, presumably, to the appellees. That's the purpose of the tortious interference with contract availability under DC law. Nobody should be calling unauthorizedly, particularly with a regulatory framework like the AALS guidance to law professors and deans, and asking about a currently employed person at all. And in this case, we also have the benefit of other materials presented in the forms of Exhibits 5. These are heavily redacted Appellees exhibits that are in the Joint Appendix at pages 129, 132, 137, 143, 258, and 148, and these are heavily redacted communications between Appellee and their co-defendants, Campbell University and others. And for these reasons, under the rule of Witt, which both the court below and Appellees ignored and under the proper application of Sidwell Friends, which the court below did cite, we respectfully request a remand for at least discovery, because the facts are pleaded in this jurisdiction as they're supposed to be. The 3 paragraphs of analysis dismissing this claim in the 9-page opinion are not recent, or they are not under the recent authority of this court in the first impression case of Witt from 2019.
Well, that's certainly true that the trial court didn't, but we look at this de novo. And so we will apply the correct legal standard, right? As in Witt, and the question remains the same. What in the complaint? What facts, what factual allegations are there in the complaint that would satisfy the standard that is set out in Witt?
And I would simply reiterate those 6 paragraphs cited on page 21 and 22 of the opening brief that were quoted earlier in the argument, Your Honor.
Okay, thank you.
Almost started talking while I was muted. Mr. Jones, we are going to now hear from Appellee, but under the circumstances, we let you argue for quite some time. We will certainly give you time on rebuttal, but you can expect that you will not get your 11 minutes because I think you used your time well in your initial argument. So we'll turn to Ms. Concrete.
Good morning, Your Honor. Sarah Concrete on behalf of the Appellee, the Catholic University of America, and I'm joined by my co-counsel, Thomas McCauley. The issue before the court today is a straightforward one, and that is whether Mr. Jones has adequately pled a claim for tortious interference with contractual relations. And simply put, there's not been a plausible claim stated. None of the elements of this claim have been adequately pled. But turning to the heart of the matter and to the focus of the Superior Court's ruling, Mr. Jones really has offered nothing more than legal conclusions and conclusory statements to support the third prong, the third element of a tortious interference claim, the intent necessary. And as we've discussed today, this jurisdiction follows the restatement of torts with regard to the law for tortious interference. And comment J to the restatement specifically talks about the different formulations that intent can take. It can be a direct purpose or desire, or it can be actions where there's not an intent directly, but where the actor knows or is substantially certain that his conduct will result in the interference. And simply put, the allegations in this case don't provide any facts that would fit within any of those formulations or allow the court to infer intent under any of those formulations. We have legal conclusions and a very scant set of facts in a 365 paragraph complaint. Only perhaps a dozen or so are directed at Catholic. And those facts are simply that Mr. Jones transmitted a letter seeking employment to Catholic University, that Catholic University communicated that inquiry to Campbell, and that Mr. Jones was subsequently notified that his contract would not be renewed at Campbell. The facts here don't give us any basis to infer that Catholic would have had any knowledge about his contractual relationship, much less an intent to interfere with it. And what you generally see in a tortious interference.
Wait, didn't the letter say, well, okay, now I'm trying to remember whether there's a pleading in the complaint that says that the letter stated that he was an associate professor at Campbell.
Mr. Jones may have represented that he was an associate professor at Campbell, but that wouldn't allow Catholic to have known that merely
well, that means he has a contractual relationship, right?
Sure. And the complaint that Mr. Jones represents in the complaint that his contractual relationship expired on its own in May of 2017. So
but that's at the time that this happens, he is an associate professor. Catholic has been advised of that. It's not May 2017 yet.
Correct.
This predates that.
That's correct, Your Honor. And Mr. Jones doesn't allege that his current one-year faculty contract was in any way interfered with. In fact, he alleges that he was ultimately advised that that contract would expire per its terms. There's no allegation that was
the on year. It's that 7th year.
Correct, Your Honor. His allegation is that the subsequent year that there was an entitlement to future employment at Campbell University for the 2017-2018 year, and that was where the interference arose. But for purposes of Catholic's knowledge at the time of this communication, even if it could be assumed that or it has been alleged that he represented that he was an associate professor there, there's nothing to suggest that Catholic would have known that he was entitled to any future employment there. And in fact, by sending a letter seeking employment to Catholic for the fall of 2017, he was in fact holding himself out as available and not contractually bound to
Well,
Campbell.
that was my question to Mr. Jones, and so it'll be my question to you. Is there anything that is so inherently illogical or improper, even if you're a professor, if you're a tenured professor, which is what he would have been perhaps the following year, right? Or maybe it was a 7th year, in saying, I would like to be, in essence, a visiting professor at your university?
Mr. Jones is free to contact whoever he wishes and represent that he's interested in employment. I don't believe he identified a visitorship relationship as being the object. And in fact, the letter itself indicates that he's reached his apex at Campbell University and is seeking to make, I believe, a sensible institutional change.
Well, we have to be careful here, because one of the problems with this case is we're trying to look at this as a 12B6 motion. Mm-hmm. So looking only at the pleadings and the complaint is an extensive complaint. But there's a lot of references to documents that were really attached to your alternative motion, your client's alternative motion for summary judgment, and those we should not be looking at now, right?
Your Honor, no. However, I do believe that there's authority that would support the fact that the court could consider documents that form the basis of the claim. And therefore, if the court was so inclined, would be authorized to look at, for example, Mr. Jones's February 20th letter. But to your point about what Catholic could have been inferred to know based on that letter that it received in February, at best, the only inference that could potentially be drawn is that he was employed at Campbell as of that date. Is the fact that he suggests that he's to be tenured. If anything, under Mr. Jones's argument, a tenured professor does not have a contract for terms. And so I think it's
but has a contract, right?
Well, he suggests that the only faculty members who would be under a contract would be a tenure track professor prior to the receipt of tenure.
Shifting back over to the third element, your opponent argues that the dean at Catholic who communicated this ought to have known that by kind of spilling the beans that one of the Campbell employees is out looking for employment without getting the permission from the Campbell employee. I don't mean to, or associate professor who has an association of some kind with Campbell, that was going to create problems, and that everybody knows that, and that in fact the American Association of Law School guidance would have applied to Catholic and reflects a view that that's just, it's trouble, and everybody knows it's trouble to pass that information along, and that if you know all of that, then it is a plausible inference that the dean at Catholic either intended or at least would have known that it's substantially certain that that was going to wreak havoc with the contractual interactions or relationships, current or perhaps prospective, between Professor Jones and Campbell. What's your response to that line of reasoning?
Well, my response to that would be that there's not facts in the complaint that would allow us to draw that inference. There's not facts suggesting that it would commonly be considered improper. There's no facts that suggest that even if it was that Catholic intended such a communication to have any impact on his employment, there's theoretically numerous reasons that communication could have been sent, but none of the facts in the complaint could lead us to an inference that it was done with an intent to somehow interfere with Mr. Jones's employment. And I think an important point is, in a tortious interference case, the element of intent can often be supplied by an allegation that there would be some sort of benefit or advantage to the defendant from inserting itself into another's contractual arrangement. In a real estate context, the defendant often would obtain the property that was otherwise previously contracted to someone else. in the Costco Marina case, the defendant, the element of intent was met because the defendant was alleged to have held up an assignment contract because he sought a more favorable lease term. There was an upside to the defendant. And in this case, all we have is an allegation that a communication was sent. And that alone cannot supply the necessary inference that there was any intentional conduct that was nefarious or otherwise done in a manner that would have or in a way that Catholic knew or was substantially certain would harm Mr. Jones.
Well, what if the content of the note, as we now know it to have been, had been pled in the complaint? Would that have been a difference? I think you would be interested in this. Isn't there kind of an implication in there that, what's up? What's up with this?
For example, if the email from Dean Attridge had been verbatim in the complaint, Your Honor, actually, I don't think it advances the ball at all, because all that says is FYI. It's essentially a forwarded email with no commentary about Mr. Jones, no disparaging statements, nothing that would otherwise suggest any intent by Catholic that Campbell should take any action with regard to Mr. Jones.
Why? Why send it? Why an FYI?
Your Honor, again, there's no facts in the complaint that would suggest any motivation from Dean Attridge. It's
just a complaint, discovery comes after. Why would somebody send an FYI? Somebody's just applied to me. I mean, it can be, as a trial court seemed to think, there could be a completely benign explanation, but there could be a not so benign explanation. And without going into ill will, but of course we also know that there's a context here, right? There's a complaint filed with the EEOC. Deans of universities, I assume, talk to each other about what's happening. I mean, there are inferences that could be drawn, and the question is, why would you send this as an FYI?
Your Honor,
I think you'd be interested in this.
Well, based on the facts that we have before us, it would be speculative to consider the various reasons that the dean would send this.
That was the trial court's bottom line, right? That it would be speculation.
Speculative.
Mm-hmm.
I would like to briefly address Mr. Jones's recitation of several paragraphs in the amended complaint that he pointed out as speaking to the element of intent, and specifically paragraphs 361 through 364. Those speak to the issue of privacy. And, whether Mr. Jones alleges that these were private communications and that he believed them to be so does not necessarily have any impact as to how Catholic viewed them or treated them. And I'd also like to point out that these paragraphs were included under a separate count in the complaint, count 12, which was public disclosure of private facts. And that claim was abandoned when this case was still pending before the U.S. District Court in the District of Columbia. Mr. Jones withdrew that claim. So it was not before the Superior Court when this case was subsequently remanded. And these facts aren't incorporated by reference into count 11 either. And so I just think it's important to know that, notwithstanding that, nonetheless, those facts alone do not give rise to any inference that could be drawn to suggest intentional conduct by Dean Attridge or Catholic University.
If the complaint had pled, I applied to Catholic University, I said in the letter, I want you to keep this communication confidential because, I'm being considered for tenure. And then it's disclosed.
That's a different factual scenario. That's
what's missing here. That's what's missing here, and that's what you say the American law schools think does not supply.
Well, I don't know that it would be dispositive of this question, but it would certainly be a fact that could be pointed to that there was a direction that it should be kept confidential. But here we don't have any allegation that such a communication was confidential or directed to be maintained confidentially. I think you have to keep in mind this is an unsolicited communication from a professor to another institution. Whether there's a one or two sentence reference to these AALS guidelines, but there's no allegation as to what types of communications they specifically apply to, that Catholic University would be bound by them, or that it would even apply to an unsolicited communication as opposed to a communication, employment inquiry that's through the AALS system. And so I don't know that the AALS guidelines would ultimately have a dispositive effect on whether or not a communication could be relayed to someone else.
I'm sorry, are you saying that there wasn't enough pled with respect to the AALS guidelines, or that they don't apply if we were to look at them and interpret them?
I'm saying that there's been a reference to those guidelines in the complaint, but
Right.
It's unclear what the extent or impact or relevance of those guidelines would have to this specific communication.
It's unclear because the guidelines are unclear?
There's simply a reference to AALS guideline or protocol, not that such a protocol sets forth specific parameters that would otherwise have prevented Catholic University from making this communication. I just think that ultimately we have a communication from an applicant to an institution seeking employment with no expectation of confidentiality, nothing that was not alleged that it was intended to be.
I'm sorry, so I'm still trying to get clear. Are you saying that not enough was pled with respect to the AALS guidelines, or that if we were to look closely at the AALS guidelines, we would say, of course, they don't apply to this?
The former, Your Honor. There's simply a
So it's a pleading issue. Well, I say that because I know we recently had a case where there was a reference to another, to a case decided in another jurisdiction and there wasn't much pled about what it said, but we said there certainly was enough there for someone to go and look up the case and read it.
Understood, Your Honor.
Mm-hmm. Okay.
Understood. Well, I'm out of time, Your Honor, but I'm happy to field any additional questions.
I don't have any more.
Judge, sir, you're muted.
I'm muted. So sorry. Thank you, Ms. Konchak. We will now hear from Mr. Jones for just a few more minutes in rebuttal.
Very briefly, thank you, Your Honor. Counsel for Appellee is correct when she says, appellant can write to whomever he wants and contact whomever he wants, but appellee cannot. There is a duty of care. That's why the whole tort infrastructure is in force in American law. That duty of care was breached here. I want to correct a complete misstatement. Every single paragraph of this nearly 400 paragraph complaint was incorporated under count 11, tortious interference with contractual relations, line 353, paragraph 353, plaintiff hereby incorporates as though restated each of the above paragraphs. That includes the references to the AALS guidelines, which were also briefed for the trial court. So these facts in the top of the complaint that might have been related to public disclosure were incorporated in the well-pleaded complaint. I'd also want to call the court's attention to just the case that the trial court called unlike this one, and that's the controlling case of Casca. That's the full name is here. The Casca case, and I just want to indicate that that case it's in paragraph 3 of the order of the analytical part in the last part. And I just want the court to know that we stand by our position on the applicability of Casco Marina Development Corporation. That factual scenario is very much like this one under the restatement. There are sufficient facts pleaded, but finally, just one statement about how the Witt case has recently been interpreted in the U.S. District Court for the District of Columbia, and I'm happy to provide a citation, but this is an August 2019 case in which Witt is cited as standing for a more lenient view of intentionality in the District of Columbia. And it says that, like the Costa case, which says that a breach is not even necessary to happen for tortious interference to be sufficiently pled. In the case of DC2NY Inc. versus Academic Business LLC, which was at the DDC last year, Witt is cited as making very clear that here in the District of Columbia, quote, instead of the plaintiff bearing the burden of proving that the defendant's conduct was wrongful, it is the defendant who bears the burden of proving that it was not. I would suggest that these hugely redacted attachments that the appellees presented that show their cooperation and that give the full picture of their engagement, further to Judge Ruiz's questions, that that this be remanded for more work on figuring out what's being hidden in these 6 exhibits, 5, 7, these are appellees exhibits, and the joint appendix 10, 12, 14, and C, where there is this cooperation. I can understand the desire to hide things, but we do have a clear record here. It's a fulsome record. And it's just improper that this case would be dismissed. And the rule of law after Witt, after the restatement, is that folks who get employment applications and inquiries can go around calling people without authorization, especially under the official guidance of the ALS. And finally, the American Association of University Professors also have weighed in on, and that's exhibited in this case in the joint appendix, on the harm of abrogating a terminal year. The terminal year, it all became very clear, and we pleaded it as we saw it at the time in December of 2017. But when it all came together, it was very clear. Campbell did their about face, and within minutes of this conduct, within 1 day of this misconduct on the tortious part of Catholic University of America, they destroyed an academic career, because when one loses the terminal year, it's over. And despite 300 applications, the appellant remains insufficiently employed. In the context of an EEOC and federal civil rights case ongoing, in which a law school, Campbell, that does not tenure Black professors and has not extended an offer of tenure in more than 15 years since the one Black person who was tenured left, who's a witness in that case now for appellant, it was a bad context for Catholic University of America to decide to meddle, interfere, disclose, and then cooperate jointly to destroy the viable economic prospects and contract of this appellant. I'm open to any questions, or to supplementally brief, or to prepare a more specific letter to the court along the lines of that which we provided in April in the transmittal of Witt. Thank you, Your Honors.
You are muted, Judge Easterly.
Doing it again. Thank you, counsel. Hearing no questions from my colleagues, the case will be submitted and this court stands adjourned. Thank you all.
Thank you.
Thank you.